Hi, and welcome to another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about defense lawyers conducting investigations. Cases that should have gone to the Supreme Court of Canada, but didn't. Michael Horswill had an appeal filed of his criminal conviction, and in his appeal he argued that his defense lawyer was not very effective in not investigating circumstances related to his case and sought to introduce fresh evidence about something the defense lawyer didn't investigate. In response, the defense lawyer indicated that he made an inquiry with the Crown about the circumstance relayed to him by his client, and that the Crown was the one who bore the obligation to investigate. Mr. Horswill's application raises very interesting questions about what ethical duties defense counsel have to investigate information in favor of their client, as opposed to simply making a request of Crown to investigate, who do have a positive duty to investigate whether or not the charge approval standard continues to be met. Unfortunately, the Supreme Court of Canada denied leave to hear the case, and we're left still with a lot of lack of clarity for how far defense counsel have to go to follow through on investigating instructions from their client. Should we construe the obligation to zealously defend your client to include conducting investigations into aspects of your client's defense that may not be readily apparent, or you may not understand, or may not be something that you can easily follow up on with the resources of defense counsel? Is that imposing too high a burden on defense counsel, who are often significantly disadvantaged compared to the state, who don't have an investigative body like the police at their disposal, who don't have the resources, financially or otherwise, that Crown Counsel do, and that the public does in investigating crimes? Or does defense counsel owe this to their clients, and is that just, the nature of the game being a defense lawyer? The Supreme Court of Canada could have clarified that and very clearly set out where the lines are on this playing field so that individuals who have lawyers are properly represented, so that the Crown is properly informed about the extent of their duties, and lawyers don't find themselves in ethical quagmires as Mr. Horswill's lawyer did. Unfortunately, that's going to be left for another case, and what extent the defense has a duty to investigate will have to be decided in another set of circumstances. You're watching Cases that should have gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos, and tune in next week for another episode.